Ignorance, mistakes, and lack of analysis cost plaintiffs and defendants hundreds of millions of dollars a year. I'm Matt Guichard, personal injury attorney with GTP Lawyers, and this is No Holds Barred. In this episode, I want to talk about two cases. Both are motor vehicle accident cases. One is, I'm going to call the lift kit case, and the other the spin-out case. Both happened up in the Sierras. Both occurred during snowstorms. The first one involved three young women who were in an SUV going up to Tahoe to have some fun. As they came down the hill on 80 into the Tahoe City area, the car went out of control. It was struck by another vehicle. It went over the guardrail and started to tumble. One of the young women was thrown out of the vehicle, and the only thing that saved her life was the snow, because the vehicle rolled down and rolled right over the top of her, and mercifully, her life was saved because the snow cushioned the impact of that vehicle on top of her. Let's talk about ignorance, and I want to say, as the lead into this, several lawyers got involved at several firms. And the first was the conflict issue that was not seen. The conflict is the vehicle spun out and there's potential fault on behalf of the driver. But that firm wanted to represent all three of the occupants. And they did for a period of time until they were taken off the case. The second was the issue of design immunity. They didn't know anything about design immunity, and there is an issue that one must look at, and that is that guardrail. Was that high enough? Was that in sufficient capacity to keep a vehicle from going over? At least it's something that needed to be looked at. How about lack of analysis? Nobody looked at the vehicle. Nobody looked at third-party liability. There was just the question of what was the insurance policy for the driver? Believe it or not, it was a $15,000 policy. And a second firm came in, analyzed it all, made many of the same mistakes and lack of analysis. But at the end, the biggest mistake was trying to have that injured party who had been thrown out, advising her to simply take the $15,000 policy that was on the driver's vehicle, and that was the end of it. Shortly after that, somebody contacted us and said, could you take a second look at this case? Because we just can't believe with the catastrophic injuries suffered by the young woman who was hit in the snow, fortunately lived, but she suffered catastrophic injuries. And we took a look at it and said, well, all right. Did anyone look at the speed of the vehicle? Anyone look at the MATE report the Highway Patrol prepared? How fast was the vehicle going? Was it really the fault of the driver? Did anyone look at the vehicle itself? Was there anything about the vehicle itself that was part of the analysis that was it defective in any fashion? Did it have a tire blowout? Was there anything related to that? We looked at it and we found out that indeed that vehicle had been lifted. What does lifted mean? It means somebody had come in, raised up the shocks, raised the suspension up so that that SUV, that top-heavy SUV, was even more top-heavy. Nobody had looked at that. We looked at it. We went back to the dealership and said, where did the vehicle, who lifted it? Well, a company lifted it called Lift Kit. And that lift kit had been done improperly so that the vehicle was an unsafe vehicle. How did we know that it was an unsafe vehicle? We went back and found out that the vehicle had initially been sold to an individual. We contacted him. We interviewed him. And he said, I bought that vehicle, and after a period of time, I said, whoa, this is a very unsafe vehicle. And I took it back to them, and they actually gave me my money back. So we learned that it was an unsafe vehicle, not just because of an analysis by our experts, but because of a person who bought it, drove it, and said, this is an unsafe vehicle. It shouldn't be on the road. That vehicle was resold to the parents of the young woman who was driving it that particular day. Was there any discussion between the dealership or Lift Kit or anyone with that family about, be careful with this vehicle. It's been lifted in such a fashion that it's unsafe. No, there was no such analysis, but there was on our part, and we got in and we found out this was an unsafe vehicle. So, was it the driver's fault? Was she going too fast? We looked at the mate report from the Highway Patrol. We saw that she was actually within the speed limit. But understand, you need to analyze what is a safe speed. It may be within the speed limit, but for conditions, it may have been unsafe for her to be driving at that particular speed in the snow. That's part of the analysis. So the driver did have some responsibility and some liability. But certainly, the major liability was the vehicle itself. It was an unsafe vehicle on the road, much less in the snow. We took the deposition of the initial Highway Patrol officer who wrote his report. And he said, no lifted vehicles should be driven in the snow up in the Tahoe area. Whoa. And that's coming from an expert who does this and sees accidents like this every single day. The conflict issue is huge, and many times lawyers miss it. In their zeal and in their haste to sign people up, they oftentimes don't look at the issue of there's a conflict between the driver and that injured passenger. And what is that conflict? Well, the driver is certainly potentially at fault, and how can a law firm represent both the driver and the passenger? What if there's money collected from a third party? What about that accident that happened just before it flipped over? That third party had some insurance. So how are you going to split up? How are you going to allocate between the driver who was injured, but nothing like the catastrophic injuries of the other young girl who was thrown from the vehicle? There's a conflict there. In all cases, that conflict should be recognized, and in our view, it's not even a conflict that can be waived. Conflicts can be waived. In this case, that person should have been referred out. We looked at it and said the person that we want to represent is the seriously injured party. So we referred out the driver. And that's how you look at a case from the conflict standpoint. From the vehicle standpoint, we looked at that and we hired an expert. And at times, you have to hire experts to come in. The highway patrolman was an expert. He wasn't hired by us, but we took his deposition and we learned. We interviewed the person who had previously purchased the vehicle when it was brand new, and we learned it was an unsafe vehicle. We went to the dealership and said, who lifted this vehicle? Did you lift it? No, we didn't. There's a private company that we hired, and that private company was LiftKit. By the time we analyzed the case and looked for LiftKit, they had gone into bankruptcy. The analysis should then be, did they have an insurance policy? So we went to court, and we got an order from the court that we could go after the insurance proceeds rather than going after the company itself because it was protected by the bankruptcy court. So to the extent of the insurance proceeds on that bankrupt LiftKit company, we went after that. Ultimately, we resolved the case just before trial. So at the end of the day, for our client, the most catastrophically injured of all three of the young women, we got her the $15,000 policy from the driver's insurance policy, and we got her $1.5 million in damages from the other parties. And that is a direct result of careful analysis. Now let's talk about our second case, the spin-out case. That case involved, again, a motor vehicle accident up in the snow. Two young men, a father and son, both adults, were driving in the snow, and the son was driving. As a result of speed, he spun his vehicle out, put his vehicle in a dangerous place, and another vehicle coming down the road within the speed limit didn't have time to stop, and I'll say it was nighttime, crashed into the vehicle and killed both the father and the son. That case we handled after another firm had analyzed it and said, there's no fault because it's the fault of the son driving the vehicle. no fault on the part of the second party. In California, we have a speed law. And what is a safe speed? It may say 65, it may say 45, it may say 35. But for conditions, a safe speed in that particular accident should have been 0. Sight lines were clear enough for a long period of time. That second vehicle should have seen that vehicle spin out. We've got a concept in our law of comparative fault. And in that case, there was some fault on the son's part. There was some fault on the second driver. There's some comparative fault. And you need to analyze that. So the initial firm that handled that case said, well, we're not going to handle it. There's no liability. And they represented both the father and the son, the estates for both of them. When we took a look at it, we said, well, first of all, there's a conflict. The son, as the driver, caused the initial accident. So the play should have been separate attorneys, and the estate of the father should have sued the estate of the son and gathered the insurance policy that the son had on his vehicle, which was substantial. That requires 2 separate firms. Also, the analysis should have been that although there was some fault on the part of the son, there was also some part on the second party who came upon the accident at an unsafe speed, even though the vehicle analysis from the CHP was that that vehicle was traveling within the speed limit. But the speed limit at that time was unsafe for those conditions. We were able to get a policy of insurance, which we deemed at the time substantial, for the estate of the father. We collected that. And then we had a discussion with the carrier for the second vehicle, and ultimately we reached a satisfactory result. They contributed with the idea that there was 50% fault on the part of the driver, the son. Careful analysis, lack of mistakes, lack of ignorance, a just result in that case as well. So interestingly, is a lot of people, and we try not to talk about the recoveries in some cases. It sounds a little like bragging, yes, and sometimes we are bragging. In this particular case, you might know that there was a 300-500 policy that the son had on his vehicle, and we were able to collect that 300. 300-500 policy means that there's, for a single person, there's a 300 coverage. For multiple people, there's 500. So we were able to collect the entire 300 for the father's estate. With respect to the second, there was a 100-300 policy. There were 2 people involved. We argued for the 300, and in fact, the insurance company agreed there was comparative fault somewhere in the 50% range. So we collected $150,000 for the estates of both the father and the son in that particular case. And the reason why that's important is because we mentioned before, the original attorneys who were involved said, fault on the part of the son, no liability, nothing to recover. And after careful analysis and looking at all the facts and the law, we were able to get a significant recovery for both estates. So in all these cases, at the end of the day, it's never going to bring back a loved one. It's never going to take care of all that heartache. But we were able to gather $450,000 in total recovery for the estate of the son and the estate of the father. And the father who had a wife, a loving wife, and again, it'll never bring him back. But that money helped her and will help her for the rest of her life. So thanks for watching. This is Matt Guichard. We look forward to seeing you at our next episode of No Holds Barred.